The definition under the Public Officials Employee Ethics Act, 65 PS 410, conflict or conflict of interest. Use by a public official or public employee of the authority of his office for employment or any confidential information received through his holding public office or employment for the private pecuniary benefit of himself, a member of his immediate family, or a business with which he or a member of his immediate family is associated. The term does not include an action having a de minimis economic impact or which affects to the same degree a class consisting of the general public or subclass consisting of an industry, occupation, or other groups, which includes the public official or public employee, a member of his immediate family or business with which he or a member of his immediate family is associated. The law then states, it defines business with which he is associated is any business in which the person or a member of the person's immediate family is a director, officer, owner, employee, or has a financial interest. And the law then makes it a violation under restricted activities. No public official or public employee shall engage in conduct that constitutes a conflict of interest, and that includes a voting conflict. And under voting conflict, it says, where voting conflicts are not otherwise addressed by the Constitution of Pennsylvania or by any law, rule, regulation, order, or ordinance, the following procedure shall be employed. Any public official or public employee who in the discharge of his official duties would be required to vote on a matter that would result in a conflict of interest shall abstain from voting and prior to the vote being taken, publicly announce and disclose the nature of his interest as a public record in a written memorandum filed with the person responsible for recording the minutes of the meeting at which the vote is taken, provided that whenever a governing body would be unable to take any action on a matter before it, because the number of members of the body required to abstain from voting under the provisions of this section makes the majority or other legally required vote of approval unattainable, then such members shall be permitted to vote if disclosures are made as otherwise provided herein. In the case of a 3-member governing body of a political subdivision, where one member has abstained from voting as a result of a conflict of interest, and the remaining 2 members of the governing body have cast opposing votes, the member who has abstained shall be permitted to vote to break the tie if disclosure is made as otherwise provided herein. And so the question for each goes to the relationship of each with any business or entity that would benefit from any vote that this board takes, and as it relates to family members and any business or entity that they are associated with that would benefit.
All right, I think they've given their answers, implied answers.
At this time, we'd like to have 2 subpoenas issued under the board subpoena authority for Al Magnotta and David Osborne. And we ask that those be issued so that they're required to appear at the next hearing, and we ask that this proceeding be continued to the next hearing.
Mr. Chairman, those are our expert witnesses. He doesn't have the right to subpoena our expert witnesses. He can't compel an expert witness to testify. He simply can't. And we object to the issue of subpoena for our expert witnesses. Let him present his case to his own witnesses. Obviously, the first one didn't work out so well. Maybe you should find another. But he cannot subpoena our experts.
They are fact witnesses based on their involvement with Keystone Sanitary Landfill, and I'd be calling them fact witnesses.
Okay, so I just want to make my own note. So it's Al Magnotta.
Right, and David Osborne.
Yes, Mr. Chairman, if these are fact witnesses, we'd ask for an offer of proof as to what facts he attempts to elicit through our experts.
And would agree with that. Are you planning on calling it?
Depending on the applicant's case, what was our intention? The applicant's case.
Certainly, the board has the board has subpoenaed him. That's not. We we understand that your request for the subpoena is, that you want to have them, if the subpoena is issued, you want the subpoena to command their, presence here next week, and we'll take that under advisement.
Can we have an offer of proof as to what facts he attempts to elicit through our experts?
Well, he's stated that he wants them as fact witnesses.
That's right.
And so, on that basis, we'll make our decision.
But shouldn't we know that whether the facts are relevant, the facts that he attempts to elicit through our witnesses are relevant and germane to the issues before the zoning board?
Well, I think that depending upon the testimony, there'll be a determination of whether his questions are appropriate or not. And we realize that the rules of evidence don't strictly apply. But it's just something that the board has to consider. We understand your request and we'll advise both parties what the outcome is.
Are you demanding that we subpoena them, or can we take a few days to compel them to come?
Well, I think it would be, I'm careful not to demand things of anyone. I have a 16-year-old daughter, and I find that sometimes backfires. But with all due respect, it is ultimately the board's determination. I think it's in the best interest of all parties and the witnesses, for the convenience of the witnesses, for the board to rule on the matter quickly. And to be clear, these are people who are directly involved in the landfill on a daily basis, not just in relation to its current operation, but in connection with its proposed expansion. And so they would have a significant fact about the nature of the landfill and the nature of the expansion.
Mr. Chairman, we'd like the board was kind enough to give the objectors, the appellants, 10 days to respond to what was submitted. We'd like to have 10 days to address the legal issues that they're trying to subpoena our expert witnesses. And that's the same response time they had on the motion to dismiss. So we'd like that equal amount of time to address the legal issues of subpoenaing other adverse parties' expert witnesses.
That was without, that time which was offered by the board solicitor was not going to disrupt the ability of any party to present its case in a timely manner.
And Mr. Chairman, the other thing I just want to repeat, and I know Mr. Greco has made a statement, there was a reference that formal rules of evidence shall not apply, but irrelevant, immaterial, unduly repetitious evidence may be excluded. So again, I think it would be appropriate to have, particularly for an extraordinary subpoena of others, expert witnesses, to have an offer as to what relevant and material evidence the appellants here attempt to produce or present to the board through other people's experts.
I just stated it. And I think it's quite clear that these are people with direct personal knowledge of the nature, design, the construction of the landfill as it currently exists and as it's proposed.
We understand your request.
And again, we ask for a ruling tonight if possible, and we have time still set aside for tonight's hearing. And so we would request that the board deliberate and issue the subpoena.
Yeah, okay, well, the board won't make the decision tonight. We just want to make sure that we're considering the applicable law and that does so. So I certainly understand your request, but I know you understand that the board wants to make sure that they're evaluating your request properly.
We would include a document that the subpoena include documents if the board is going to be considering the subpoena after tonight. Then I can submit in writing the documents that we would be requesting to be compelled, and I can provide that to the board by close of business tomorrow. But I would like to know what the board's timing is. If you need something tonight, we can provide it tonight.
No, I think if you provide your list by the close of business tomorrow, also provide it to the
Of course.
opposing counsel.
Mr. Greco, I can get your
Yes.
card,
And
will you not